This video discusses the different articles covering loss, deterioration, and breach. Excerpts are from De Leon's The Law on Obligations and Contracts. Welcome to the course. Article 1189 is a long article explaining in detail things which can happen on a thing during the pendency of the condition. There are three cases: in case of loss, deterioration, or improvement. The article states, when the conditions have been imposed with the intention of suspending the efficacy of an obligation to give, the following rules shall be observed in case of the improvement, loss, or deterioration of the thing during the pendency of the condition. First, if the thing is lost without the fault of the debtor, the obligation shall be extinguished. Second, if the thing is lost through the fault of the debtor, he shall be obliged to pay damages. It is understood that the thing is lost when it perishes, or goes out of commerce, or disappears in such a way that its existence is unknown or it cannot be recovered. Third, when the thing deteriorates without the fault of the debtor, the impairment is to be borne by the creditor. Fourth, if it deteriorates through the fault of the debtor, the creditor may choose between the rescission of the obligation and its fulfillment, with indemnity for damages in either case. Fifth, if the thing is improved by its nature or by time, the improvement shall inure to the benefit of the creditor. And sixth, it is improved at the expense of the debtor, he shall have no other right than that granted to the usufructuary. More examples are shown on the succeeding discussion. There are three kinds of loss as identified in civil law. One is physical loss, which can be described when a thing perishes, like when a house is burned and reduced to ashes, or food gets rotten. Legal loss happens when a thing goes out of commerce, for example, when it is expropriated, or when a thing heretofore legal becomes illegal, such as the old currency which lost their value upon the arrival of the new banknotes. The third kind of loss is civil loss, described when a thing disappears in such a way that its existence is unknown. For example, a particular dog has been missing for some time, or even if known, it cannot be recovered, whether as a matter of fact, that is, particularly a necklace dropped from a ship at sea, or of law, a property is lost through prescription. Details of the article can be explained by rules in case of loss, deterioration, or improvement of thing during pendency of suspensive condition. The first case is loss of thing without debtor's fault. Let's take this situation. A man obliged himself to give his friend his car if his friend will sell his property. The car was lost without the fault of the man. The obligation is extinguished, and the man is not liable to his friend even if his friend sells the property. A person, as a general rule, is not liable for a fortuitous event. The second case is loss of thing through debtor's fault. In the same example, if the loss occurred because of the negligence of the man, his friend will be entitled to demand damages, that is, the value of the car plus incidental damages, if any. Another case is the deterioration of thing without debtor's fault. A thing deteriorates when its value is reduced or impaired with or without the fault of the debtor. In our example, if the car figured in an accident as a result of which its windshield was broken and some of its paints were scratched away without the fault of the man, thereby reducing its value, his friend will have to suffer the deterioration or impairment in the amount of the damage. The fourth case is deterioration of thing through the debtor's fault. Using the same example, where the man is negligent, his friend may choose between first, rescission or cancellation of the obligation with damages. In this case, the man is liable to pay the amount of the car before its deterioration plus incidental damages, if any. And letter B, fulfillment of the obligation also with damages. In this case, the man is bound to his friend to give the car and pay the amount of damages plus incidental damages, if any. The fifth case is improvement of thing by nature or by time. A thing is improved when its value is increased or enhanced by nature or by time, or at the expense of the debtor or the creditor. In the same example, suppose the market value of the car increased, who gets the benefit? The improvement shall inure to the benefit of his friend, inasmuch as his friend would suffer in case of deterioration of the car through a fortuitous event. It is but fair that he should be compensated in case of improvement of the car instead. The last case, improvement of thing at the expense of the debtor. In the same example, during the pendency of the condition, the man had the car painted and its seat cover changed at his expense. In this case, the man will have the right granted to usufructuary with respect to improvements made on the thing held in usufruct. Usufruct is the right to enjoy the use and fruits of a thing belonging to another. Article 1190. When the conditions have for their purpose the extinguishment of an obligation to give, the parties, upon the fulfillment of said conditions, shall return to each other what they have received. In case of loss, deterioration, or improvement of the thing, the provisions which, with respect to the debtor, are laid down in the preceding article shall be applied to the party who is bound to return. As for obligations to do and not to do, the provisions of the second paragraph of Article 1187 shall be observed as regards the effect of extinguishment of the obligation. This article discusses effects of fulfillment of resolutory condition. In obligations to give. When the resolutory condition in an obligation to give is fulfilled, the obligation is extinguished and the parties are obliged to return to each other what they have received under the obligation. 1. There is a return to the status quo. In other words, the effect of the fulfillment of the condition is retroactive. For example, a man allows his friend to use the former's car until the man returns from the province. Upon the return of the man from the province, his friend must give back the car. The effect of the happening of the condition is to annul the obligation as if it had never been constituted at all. In this case, the parties intend the return of the car. Second, in case the thing to be returned is legally in the possession of a third person who did not act in bad faith, the remedy of the party entitled to restitution is against the other. For example, a man binds himself to give a sum of money a month until his friend passes the CPA examination. If his friend passes the CPA examination, he need not return the amounts he has received. It is clear that the parties do not intend the return of the same. In obligations to do or not to do. In such obligations, the courts shall determine the retroactive effect of the fulfillment of the resolutory condition, as in the case where the condition is suspensive. The courts, in the exercise of discretion, may even disallow retroactivity, taking into account the circumstances of each case. The next article, Article 1191. The power to rescind obligations is implied in reciprocal ones in case one of the obligers should not comply with what is incumbent upon him. The injured party may choose between the fulfillment and the rescission of the obligation with the payment of damages in either case. He may also seek rescission even after he has chosen fulfillment, if the latter should become impossible. The court shall decree the rescission claim, unless there be such cause authorizing the fixing of a period. This is understood to be without prejudice to the rights of third persons who have acquired a thing, in accordance with some articles and the mortgage law. This article discusses kinds of obligation according to the person obliged. We've got, first, unilateral, when only one party is obliged to comply with a prestation. For example, donation. In a contract of loan, the lender has the obligation to give. After the lender has complied with the obligation, the debtor has the obligation to pay. Second, bilateral. When both parties are mutually bound to each other, in other words, both parties are debtors and creditors of each other. Bilateral obligations may be reciprocal and non-reciprocal. The first from the two further classification of bilateral obligations is reciprocal obligations, or those which arise from the same cause and in which each party is a debtor and creditor of the other, such that the performance of one is designed to be the equivalent and the condition for the performance of the other. An example is a client paying an engineer for the construction of his project. The other classification is non-reciprocal obligations, which are those which do not impose simultaneous and correlative performance on both parties. In other words, the performance of one party is not dependent upon the simultaneous performance by the other. There may be two obligations, but they are not connected. It may be that the man loans his friend some cash, but he also would like to borrow his friend's car. Although both of them are debtors and creditors of each other, their obligations are not reciprocal. The last article under different kinds of obligations is 1192, which states, in case both parties have committed a breach of the obligation, the liability of the first infractor shall be equitably tempered by the courts. If it cannot be determined which of the parties first violated the contract, the same shall be deemed extinguished and each shall bear his own damages. The above article contemplates two situations where both parties are guilty of breach. The first is first infractor known. One party violated his obligation. Subsequently, the other also violated his part of the obligation. In this case, the liability of the first infractor should be equitably reduced. The second condition is first infractor cannot be determined. One party violated his obligation, followed by the other, but it cannot be determined which of them was the first infractor. The rule is that the contract shall be deemed extinguished and each shall bear his own damages. In effect, the court shall not provide remedy to either of the parties, who must suffer the damages allegedly sustained by them.